Hello, everyone. This is Gilbert Gelada. I'm talking to you here from Private Corporate Counsel. This is Tufts on Tax, where all your tax questions and answers are right here with Mr. T. Scott Tufts when it comes to taxes and litigation. You can reach him at 407-647-7887. And that same number on an 800 number, also it's 877-647-7887. You can reach him. Email him at stufts@pcc.law. That's stufts@pcc.law. Or you can visit the website at privatecorporatecounsel.com. Hello, Scott. How are you?
Hey, good to be with you.
Good to be with you too. And today we are talking about another case, which is the Farhy case. And that's a little bit interesting because we're going to tackle about, people
here in the U.S. who have foreign businesses, and how the IRS can require them to report those interests. So we're very much in a world of transparency, and we have forms that are not so much about taxes as much as they are just disclosure forms. So what we mean there is IRS and our Treasury Department just wants to know about the interest that you hold. And if you have interest in foreign companies, you're a U.S. person, meaning that you're a citizen or a resident here, you have to disclose your interest in foreign companies. Okay.
So if this is this amount of money that if you made it here in the U.S., and you deposit it or save it or keep it in a foreign country, and it makes interest in these banks, we have to report.
No, it's not. And but it's not just that. What we're talking about is if you have signature authority over a foreign bank account, that's called the FBAR form, or, the FinCEN requires that. We're talking about if you have beneficial ownership, we have the new beneficial ownership of interest form that is going into FinCEN. And all it is disclosing that you have control or interest in a controlling authority in any company, the FinCEN. So these are not tax-based concerns. These are just information reporting concepts. Just like a 1099 is an information return.
Correct.
Well, so is these forms. These forms are gathering data and reporting the government what the extent of your holdings are when you own international interests. So if you have a foreign corporation, there's the tax form that is used to report that interest, meaning not like interest income, but a stock interest, a ownership interest, a controlling interest, an indirect ownership interest. Maybe it's owned through a trust or whatever. So these forms and whatnot are part of disclosures that you make. So what this case came out in Farhy is out of the District of Columbia Circuit Court of Appeals, May 3rd, so pretty timely, and it's an appeal from the tax court. What was interesting here was someone had refused to pay. First, they were required to file these information returns. All right.
Is that Farhy?
Farhy. So Farhy's required under the information, under the tax laws to file that. The government claims he owes nearly $500,000 in penalties for failing to comply with these rules.
500,000
in
penalties?
Yes.
Oh my God.
So very confiscatory. So they have severe penalties if you don't disclose these interests.
Right? How long has this been out there? Like, have we always did the IRS always require that, like for decades?
Yes,
or is this
it's been a component of our system for quite some time. I was just looking. I think the case discusses 1982.
Oh, wow.
So it says in the case, in 1982, Congress amended Section 6038 to bolster its enforcement. This was under TEFRA. It said that the foreign tax credit penalty was overly complicated, so they worked on that. And then they continued to enhance this reporting standard of your interest in a foreign company. And so they've had it for quite some time. Before that, they've always had a measure of trying to report, some aspect of it. In 1960, this section was initially enacted where the sole penalty for failure to file a form reporting your control of a foreign business. Back then was 10% reduction of your foreign tax credit. So the idea being that we've gone from 1960 with some measure of, oh, here's a form and your penalty might not be that big a deal, to raising the stakes along the way for failing to file the form.
1982, and then now.
So we've transcended quite a bit of time, and the penalties are severe for your failure to file. And so what we are getting at with Farhy here is the IRS went after the penalty and then sought to lien his assets and go after him. And then the idea was that they had a remedy to pursue it in tax court. And the question was, well, maybe the tax court can't hear these things, that you have to get sued somehow in federal court. And the lower court determined that tax court could not be the place where this would get decided. Okay. So he got a very favorable ruling at the tax court level. The government appealed and it was reversed. And the government argued successfully on appeal that this reporting mechanism can be enforced and penalized and collected upon in the tax court. Make sense? So let's back up. The facts of the matter were that a permanent resident, Mr. Farhy, developed a scheme. This is alleged in the opinion. Developed a scheme to falsely underreport to the IRS his income from exercising certain stock options he received from his then employer, seeking to fabricate losses to reduce his U.S. Reportable income. It is alleged that he transferred more than $2 million to a sham foreign entity, which then transferred the funds to a bank account in the name of a Belize-based, that's in the Central America, corporation that Farhy created solely for that purpose. The allegation is that his scheme violated a variety of tax-related obligations beyond his duty to correctly report and pay the income tax. Most relevant, he failed to report to the IRS his control of these foreign financial accounts and the foreign corporations he used. In 2012, he signed a non-prosecution agreement with the tax division that immunized him from criminal prosecution for his failure to disclose his offshore accounts, provided he cooperated fully and truthfully with tax enforcement authorities. So, in other words, they went after the foreign bank accounts in order to avoid jail. He entered into a non-prosecution agreement. He agreed to fully cooperate. As part of that fully cooperating process, he has to comply with his civil tax liabilities. At that point, the IRS mailed him a notice that said that between 2003 and 2010, he had failed to file these forms to disclose his ownership of this Belize corporation. All right. More than 2 years later, when he still had not refiled the required forms, the IRS assessed initial and continuation penalties totaling $60,000 per year. So think about it, Gilbert. They're going back to 2003 through 2010.
$60,000 a year.
Now, yes. And think about this. They don't file their first notice to collect on this until 2016. So in 2016, the IRS wants penalties for a person's failure to file these forms at $60,000 a year penalty from 2003 to 2010. So the idea that there's a statute of limitations here, you notice that we're not talking about statute of limitations.
How come?
Because there is no statute when you don't file these forms.
Oh, wow. They can do that.
Yes. So very serious. So our audience needs to know that. So these forms, failing to file and report a foreign corporation, your ownership interest in it. Think about beneficial ownership. You're going to have to report any interest you have in any company in 2024 as to your indirect ownership. So you can't go through a trust and say, well, I don't really own it directly. So you got that problem. Then you've got $60,000 per year of noncompliance if you haven't filed these penalties. And if they can pick it up at any time, you can see the problem, right? Because it's catastrophic, right? I mean, and again, he had already done the non-prosecution, but you think about it, he's going to cooperate fully. which also includes you're going to pay your taxes. So you see the catch, you're avoiding jail time, but now here come these things, which
penalty, the taxes.
Absolutely. And so it's a huge, concept for many of our audience to understand that just failing to file a form can create a huge penalty, and there's no statute of limitations with regard to it.
So if he filed that form, he was supposed to file that form every year?
Every year.
And then depending on what changes in his assets or
right. But it's so it's a form that just discloses your ownership interest in a foreign corporation.
And if he
or business
provided that form or
he would not have this penalty.
And he still has to pay taxes.
Right. If on the income earned in that corporation or whatnot,
or in that area.
Right. If it's subject to tax and comes back.
But at least he would have avoided court and the penalty. Right.
But he would have, by filing a form that just says he has an interest in a foreign corporation.
As simple as that.
As simple as that.
So why would people avoid doing that? Is it negligence, or is it thinking that they want to hide their assets, or what would be the reason to avoid that?
Well,
since you're saying this came out in the 60s, starting this whole
concept
thing,
of we want to know about your correct.
And then it was solid in 1982, and now it's even more. So why would someone over these decades and these years known in the IRS and the forms that you should do that, they would avoid doing something like that?
Yeah. So, you would think that you'd want to be compliant, but remember, again, he didn't report the foreign accounts that led to the prosecution. He did a non-prosecution, avoided going to jail for not reporting his foreign bank accounts. So if you think about it, he's avoiding one problem, but he's still got another one because he's agreed to cooperate. And then in that cooperation phase, he's got to look back and say, did he file all those forms?
What a mess.
And the IRS has procedures to let you try and late file. But if you don't respond and then they have to come to you, then they've come to you to report the information.
Is this case still going on? Or
so this is the Court of Appeals. So unless he can get the United States Supreme Court to consider this decision, it's going to stick. And if it sticks, then the tax court can necessarily determine and arbitrate and decide upon these kinds of failure to report information returns and the penalties and so forth. So it's a very significant decision. We wanted to get out in front of this for our audience, but it really gets back to the idea that we're in a very transparent world in terms of you filing these forms and doing these different things. And if you don't file the forms, there may not be a statute of limitations. So therefore you can get into significant penalties that you wouldn't think applied for something so long ago.
Yeah.
And so it's a pretty serious issue that our audience wants to do. So I think, the takeaway here for our audience is if you have international interests, you need to know about these reporting forms. You need to make sure that your accountant is aware of them and that you're filing all the necessary disclosure forms, and that you're not taking an effort and if you haven't done that in the past and you haven't, you need to be aware of the statute. There's no statute that can protect you. So if the IRS provides you with notice to pay the penalties, then you're going to be in a different fight. So nothing to be gained by burying your head in the sand, right?
Yes. And does it help to have an attorney like yourself familiar with all of that and all the legal matters when in regards to that?
Where a guy like me comes in is quite frankly, if the accountant should have known about it, and the accountant, you disclose it to your accountant doesn't do it, that you might have reasonable cause, defenses against this, or you might at least try to defend on that basis.
This is where you can.
Yeah, someone like me would come in to defend that. Also, I could, fight the penalties in the court based on the arguments I'm talking about. If the defense is beyond just not filing a form. It would be like appearing in tax court and fighting and litigating issues. I certainly can do that for folks. And then fighting it in federal court as well, or any court. These issues can.
But even before it reaches that level, I think it's really smart. And if a business have such assets, to have an attorney on their side.
Well, yeah,
on their team.
Well, a couple of things. There's a statement of financial assets that you need to file also that's out there for people with foreign assets. That is something that needs to be looked at, and your accountant should be aware of it. And then as you move forward, if you have concerns about confidentiality and disclosing this to your preparer who has no privilege, then you're going to want to get back to an attorney to protect and have this kind of candor or discussion to determine how to best to proceed. So again, if you haven't filed in the past, but you come across a point in time when you needed to, your first discussion should be with an attorney like me, because you don't want to open the discussion with the accountant.
Correct.
Because there may be a dispute where you say, Mr. Accountant, I told you to file this and you didn't. Or the accountant says, no, you didn't. You and I talked about it and you said you didn't want to file the form. Well, now what do? You're having open discussions about this without probably getting legal advice first. That's confidential. So you want to have privileged discussion with an attorney about this if you get an IRS notice, for example.
Yeah, so, and I think it's smart when people reach that level to have an attorney, if they can afford it, have an attorney on their side like yourself to always go back to and make sure everything is in order and give them the advice and
100%.
And or they can be part of private corporate counsel because they have access to attorneys like yourself and other attorneys, other practices for their business.
Yeah. So anybody in the private corporate counsel situation, if they're a member in the program and they're getting and it's about their business, if they, as part of that, have international connections, then they're going to want to obviously discuss that, reveal that, and open that discussion so that there's no surprises come down the road.
Exactly.
I mean, attorneys and accountants can only go on what you tell them. So if you don't tell them you have an interest and you don't disclose that you have the interest, how are they going to know to give you the advice you might need? So there has to be a mechanism of disclosure. But the first place to have that disclosure is, especially if you haven't done it in the past, is with an attorney.
Yes, absolutely. You heard him, folks. You get the advice from the expert like Mr. T. Scott Tufts. You can call him at 877-647-7887. That number also on 407 area code 407-647-7887. And you can email him at stufts@pcc.law. That's stufts@pcc.law. Or you can visit the website at privatecorporatecounsel.com. Thank you and see you next time. Thank you.